Hi, my name is Michael Massman. I'm a consumer attorney with Neighborhood Legal Services of Los Angeles County, and I'm here with my colleague, Kelsey Atkinson. Kelsey, how are you today?
I'm doing good. How you doing, Michael?
I'm doing well also. Thank you for asking. So, we're going to talk to you about creditor options today. We're set up at the Bankruptcy Self Help Center a lot to help people file Chapter 7, but there are people on the other side of that have concerns as well. So, this is dedicated to creditors. So, Kelsey, what does it mean to be a creditor?
So, a creditor is a person who a debtor owes money to. If you're a creditor in a bankruptcy case, you may receive a document from the bankruptcy court that is a notice of the debtor's bankruptcy case. If you're a creditor and you receive one of these notices of a bankruptcy filing by someone that owes money to you, it's really important that you read that entire notice for all of the important information about the debtor's case and the upcoming deadlines in that person's bankruptcy proceedings.
Okay, so if you're named as a creditor and you receive that kind of notification, what options do you have then if the filer owes you some money?
So, if the filer owes you some money, the first thing you need to know is that if the person who owes you money is filed for bankruptcy, they have the protection of something called the automatic stay. The automatic stay means that the person who's filing for bankruptcy can no longer be contacted by you to try and collect the debt from them. So, once the automatic stay is in place, you have to stop all collection activities towards the person who filed for bankruptcy. Instead, to try and possibly collect the debt or see what you can do about the money owed to you, you need to go through the bankruptcy court itself and some of the bankruptcy processes set out. So, a few options are one, you can do something called filing a proof of claim. And this is something you file with the bankruptcy court to notify them that there's money owed to you, that you are a creditor and you would like to get paid if possible. The other thing you can do is attend the meeting of creditors. The meeting of creditors is the meeting with the bankruptcy court trustee where you can go and you can speak to the debtor and the trustee about the money that's owed to you. You also have the option to object to the discharge of the debt owed to you by filing something called an adversary proceeding. An adversary proceeding is pretty complicated, but in essence, an adversary proceeding is a lawsuit within the bankruptcy. And you can try to challenge and say that the debt owed to you should not be discharged as part of this person's bankruptcy case. The other option that you may have in certain situations is you can file a motion with the court called a motion for relief from the automatic stay. And so this is where you're asking for an exception to the bankruptcy rule that protects the debtor from having any collection actions taken against them to try and move forward, despite the fact the person filed for bankruptcy. So, some common situations where you may file a motion for relief from the automatic stay is if you have an active lawsuit against the person who filed for bankruptcy in state court. This is really a common thing that landlords may do if they're trying to move forward with an eviction against someone that's behind on rent. This also may come up in the context of a mortgage lender who wants to proceed with a foreclosure or a car lender who wants to repossess a vehicle.
Yeah, we see those a lot at the Self Help Center for sure, especially with regard to evictions. So, what happens if the creditor doesn't take any action whatsoever?
So, if you don't take any action, then you do risk not being able to collect that debt in the future, and the debt may be discharged forever going forward. So, that's why it's really important if you're a creditor and you receive that notice of bankruptcy from the bankruptcy court to understand what the deadlines are for filing a proof of claim or objecting to the discharge so that you don't waive those rights going forward.
Yeah, and it's important to assert those claims. I mean, one of the reasons the automatic stay exists is so that if there is money to be distributed from the bankruptcy estate, that creditors get an equal share that's appropriate to their claim. And so that's a function of the automatic stay as well. It's not just to protect the debtor, it's to protect the creditors as well, no?
Yes, definitely. So that's part of the overarching goal of bankruptcy is to have an orderly approach to dealing with someone's debt and dealing with their creditors. And that involves the bankruptcy trustee lining up the creditors in order of their priority and then distributing any money or assets that the debtor may have in order of priority. So it allows for a more organized distribution of any assets that the debtor may have.
Perfect. So again, if you are a creditor and somebody you know has filed Chapter 7 and you're interested in your rights, you are welcome to come down to the Bankruptcy Self-Help Center or give us a call and talk to us about those options.